Well, good morning, everybody. Welcome to Landmark Chamber's latest webinar. And today we're going to deal with Neighbourhood Plans, the latest law and policy. And I just want to thank you very much for joining us. We're delighted to have so many of you here today, and I hope you'll find today's webinar informative and of assistance in your everyday practice. Can I just deal with a few housekeeping matters? All of you, I'm afraid, will have your microphones muted, so don't adjust your local settings. We also very much welcome questions. The format of today's webinar is we're going to have 5 presentations from 5 excellent speakers, and then could you please, if you've got any questions and answers, could you please send them on the question and answer function, which is at the bottom of your screen at the right. Obviously, we ask not to be too prescriptive in terms of particular circumstances, because obviously it's very difficult for us to get a grip on matters in the specific circumstances, but don't hesitate to ask us questions, which we'll deal with at the end. The webinar is recorded, and also we do want to say that all of you will receive a link at the end of the webinar to the slides and also for the speaker biographies. So if you want to learn more about us, and if you want the slides in detail, you can get a link to access them. So don't worry too much about scribbling down notes. If for any reason you have an IT problem and your connection drops off, just use the original link to come back on. That should facilitate you coming back on. I just wanted to say a couple of matters also about our speakers, and we have, let me just show you who we've got. My name is Sasha White, QC. I'm chairing today. We're then going to hear from Kate Olley on the procedure for preparing the neighbourhood plan and the consultation requirements, particularly during the current COVID pandemic. Then Matt Reed, QC, is going to deal with the examination of a neighbourhood plan. And then we go on to Kimberley Ziya, who's dealing with the approach to the basic conditions, both from policy and law. And then Andrew Parkinson will deal with how neighbourhood plan policies are dealt with in both development control decisions and in relation to other development plans. And lastly, we finish with James Neill telling one how to challenge a neighbourhood plan and when to do so. Before we start, I just wanted to say a couple of matters in introduction. The first of which is that we should know, and I know this in terms, that the government are completely committed to neighbourhood plans. I know there's much debate about their benefit or not, but the political imperative is neighbourhood plans are here to stay. So I think all of us should observe and listen to this neighbourhood plan webinar on that basis. They're not going anywhere. The second thing is I just want you to reflect on the success or not of neighbourhood plans, and we all have views on them, but just to give some fat to the bone of the debate, I looked up on the government's website the statistics, and what is happening is there was quite a drop-off from the beginning of the process to the end. And we have a situation where 2,700 neighbourhood plan areas are applied for. We have submission of 1,145, and we have 866 adopted as of earlier this year. So what we can see is currently, for whatever reasons, a lot of plans don't finish the process from actually having an area designated. So only about 33% make it successfully through the whole line that's required. So the neighbourhood plan coverage, the third point I wanted to make is the coverage is not that strong, and we'll also discuss later on as to why. So I just wanted to give you those overviews, and now let's go on. And actually, can I please ask Kate to just start the presentation, the first presentation. Thank you very much.
Thank you, Sasha. Good morning, everyone. I will start the talks with an overview of the procedure and where we are at the present time. First, the basic legal and policy sources for neighbourhood plans, the 1990 Act, the 2004 Act, the 2012 regulations as they've been amended, and the NPPF and NPPG. The regulations make provision, amongst other things, for the procedure for making the neighbourhood plan, in particular the consultation and publicity prior to submitting the neighbourhood plan proposal to the LPA, its content, and what the LPA must do to publicise that and any neighbourhood plan eventually made. And the schedule to the regulations sets out the list of consultees for neighbourhood plans. Neighbourhood plans are referred to throughout the NPPF, and there are some key guiding points contained in here. Paragraph 12, in relation to the presumption in favour of sustainable development, says that planning permission should not normally be granted where an application conflicts with an up-to-date development plan, and that includes any relevant neighbourhood plan. Paragraph 13, neighbourhood plans should support the delivery of strategic policies contained in local plans or spatial development strategies, and should shape and direct development that is outside of those strategic policies. Paragraph 14, where the presumption applies, the adverse impact of allowing development conflicting with a neighbourhood plan is likely to outweigh the benefits, providing 4 requirements are also met, which Andrew is going to pick up on later. Paragraph 29, neighbourhood plans should not promote less development than set out in the strategic policies for the area or undermine those policies. 37, neighbourhood plans must meet certain basic conditions and other legal requirements, and this will be tested at independent examination. Paragraph 125, in Chapter 12, Achieving Well-Designed Places, neighbourhood plans can play an important role in identifying the special qualities of each area and explaining how this should be reflected in development. And finally, in paragraph 136, green belts, once the need for changes to greenbelt boundaries has been established through strategic policies, detailed amendments to those boundaries may be made through non-strategic policies, including neighbourhood plans. Some fundamental points. Section 38(3)(c) of the 2004 Act makes clear that a neighbourhood plan is part of the development plan. A neighbourhood plan, as defined, is a plan which sets out policies, however expressed, in relation to the development and use of land in the whole or any part of a particular neighbourhood area specified in it. So who initiates the process? That's the qualifying body, which is entitled to do so. What is a qualifying body? There are 3 types of organisation which can lead the process. It can be a parish or town council, a neighbourhood forum, or a community organisation. A neighbourhood forum, by the way, is at least 21 people who either live or work in the neighbourhood area or are elected members of an authority for all or part of the area. I'll run through the key stages in the neighbourhood planning process. Step 1 is to designate a neighbourhood area and, if appropriate, a neighbourhood forum. The qualifying body then submits an application to the LPA and there is consultation. Step 2, the qualifying body develops proposals, and that involves gathering baseline information and evidence, engaging and consulting, talking to landowners, identifying and assessing options, and starting to prepare the proposals documents, which will include the basic conditions statement. And it will need also to look at whether a plan will be likely to have a significant environmental effect. Step 3 is the pre-submission publicity and consultation. That's prior to submission to the LPA. Step 4 is submission of the plan proposal to the LPA, and there's more consultation then. Step 5 is independent examination and the report, and the LPA then decides whether to take the plan to referendum. Step 6 is the referendum, and step 7, the neighbourhood plan comes into force if more than half of those voting in the referendum vote in favour of it. The neighbourhood plan is then part of the statutory development plan for the area. A plan can't be put to referendum and made unless it meets the basic conditions, which Kim Ziya is going to look at in much more detail. They're found in Schedule 4B to the 1990 Act and also listed out in paragraph 65 of the MPPG. They do have to be considered throughout the process of developing the plan, so it's a good idea for the draft basic conditions statement to be shared and discussed with the LPA early on. Now, some more key points. What I'd like to particularly emphasise, a neighbourhood plan can allocate sites for development, including housing, and there's guidance on how to assess sites and viability, for example. But the MPPG advises an LPA, which is also intending to allocate sites in the same neighbourhood area, to avoid duplicating planning processes that will apply to the neighbourhood area, and asks it to work constructively with a qualifying body to enable a neighbourhood plan to make timely progress. The LPA should also share evidence with those preparing the neighbourhood plan so that every effort can be made to bring the identified local need forward through the neighbourhood planning process. A neighbourhood plan can also allocate additional sites to those in a local plan or spatial development strategy where this is supported by evidence to demonstrate need above that identified in the local plan or SDS. But it shouldn't reallocate sites already allocated through those strategic plans. The plan can also propose allocating alternative sites to those in a local plan where those alternative proposals are not strategic, but then there should be discussion with the LPA as to why it's considered the allocations in the strategic policies are no longer appropriate. Remember, the neighbourhood plan should support the strategic development needs set out in the strategic policies for the area and plan positively to support local development and not promote less development than set out in the strategic policies, and nor should it be used to constrain the delivery of a strategic site allocated for development in the local plan or SDS. A neighbourhood plan can be developed before or at the same time as the LPA produces its local plan. Where it's brought forward before an up-to-date local plan is in place, the qualifying body and LPA should discuss and aim to agree the relationship between policies in the emerging neighbourhood plan, emerging local plan and adopted local plan. And the LPA is asked by the NPPG to work with the qualifying body so that complementary neighbourhood and local plan policies are produced. It's important to minimise any conflicts, given that Section 38(5) of the 2004 Act requires any conflict to be resolved in favour of the last document to become part of the development plan. Back to the NPPG, paragraph 107 has set out changes introduced in response to the pandemic, and this supersedes any relevant aspects of the neighbourhood planning guidance until further notice. It covers referendums, decision-making, examinations and public consultation. So all neighbourhood planning referendums that have been recently cancelled or scheduled between 16th of March this year and 5th of May 2021 are postponed until the 6th of May 2021, which is provided for by the 2020 regulations, which I've set out there. Where the LPA has issued a decision statement detailing its intention to send a neighbourhood plan to referendum, then the plan can be given significant weight, where of course it's material to an application. The general rule remains that examinations should be conducted by written representations. Where the examiner considers oral representations are necessary, they should not take place in person, but by means of video conferencing or other technologies. It's not mandatory that the engagement with the public to publicise the neighbourhood plan at the various stages be undertaken using face-to-face methods, but in order to demonstrate that all groups in the community have been sufficiently engaged, including those who are without internet access, then it says that more targeted methods may be needed, including telephone or writing. And LPAs might be able to advise on suitable methods and how to reach certain groups in the community. Documents can be inspected online rather than made available at a physical location. In terms of progressing a neighbourhood plan, you can still do any work which is desk-based, of course, such as policy writing and some evidence gathering, and engage online in terms of surveys and questionnaires. Thank you very much. I'll now pass on to Matthew Reid, QC.
Well, good morning, everyone. I'm going to be dealing with the neighbourhood plan examination procedure. I'll deal with the procedures and the content of the examination process from appointment through to final report. Kate has dealt with the statutory content. I'll just reiterate it in terms of the examination process. Schedule 4B, as applied by the 2004 Act, Section 38A in particular, deals with the content and of the procedures related to the examination process. They're supplemented in part by the General Regulations 2012 and also by the PPG and by the RICS Neighbourhood Plan Independent Examiner Referral Service guidance. There's a mouthful, but it's guidance that has been endorsed by the government, and so bears recognition and scrutiny. So let's deal firstly with the appointment procedure. The examination is originally arranged by the planning authority, including the appointment of the examiner, but the examiner will only be appointed if the neighbourhood plan qualifying body consents. The Secretary of State can intervene as the Secretary of State can in development processes as well, but that's obviously pretty rare. So in terms of the examiner's position, the examiner must be independent of the qualifying body and the local planning authority, unsurprisingly, to avoid the appearance of bias, something that we'll come on to a little later on. It must not have an interest in land affected by the neighbourhood plan and have appropriate qualifications and experience. Turning then to the submission of the plan to the examination. Once the examiner has been appointed, the planning authority then sends basically the relevant documentation to the examiner, including the habitat regulations documentation and the consultation documents, which will be critical, as we'll see, to the examiner's consideration. The examiner then takes over control of the process, identifying further documents, indicating the timetable, the need for site visits, whether a hearing is necessary, and whether an exploratory meeting is required. All of that is derived from the RICS guidance, actually, rather than from the PPG. Again, a reason why it's worthwhile looking at that. But looking just at the detail of this part of the process, and specifically the consideration by an examiner as to whether or not to have an exploratory meeting, well, that's something that is generally rare, and it's generally rare because it's only if the examiner has concerns about the process that the examiner will think it's appropriate to have that further investigation. In the usual course of events, it doesn't really arise. So let's look at the evidential consideration, and something that Kate looked at a little while ago in the content of the COVID regulations. But the examiner will generally only consider the consultation representations, both the pre-submission and the post-submission stages of consultation, unless further information is requested by the examiner. The examiner's, of course, got the discretion to do that. As for late representations, that's something that the examiner could accept, but again, the guidance in RICS says that it will not be accepted unless there are exceptional circumstances, e.g. a change of circumstances. And of course, that would be something that one would expect to be an approach that's mirrored really in the development plan process, the local development document processes. So bear that in mind for the purposes of considering, if you're a consultee, that it's necessary to set out your full case at those consultation stages. So then, how is the examination conducted? Well, generally, as a rule, the examination is conducted by the consideration of written representations deriving from the consultation. But if it's necessary to have an adequate examination of the issues, or to ensure that a person has a fair chance to put their case, then there must be an oral hearing and it must be in public. There's no discretion on the part of the examiner in those circumstances. If those two threshold requirements, either one, are passed, there must be an oral hearing. But as to the questioning, that's questioning that's done principally by the examiner, unless, again, it's necessary for the adequate examination or that there is a fair chance to put a case for others to do so. Now, if the threshold for having the hearing requires it, it doesn't necessarily mean that that threshold is passed for the purposes of allowing questioning by a third party. But as a matter of practice, that's something that often happens. If there is a hearing, again, in practice, it will be limited to the specific issues justifying that hearing. Of course, it must be, because one couldn't have then a general approach to asking all sorts of questions about issues that didn't, in fact, engage the requirement for the hearing. So what will the examiner then consider? Well, the examiner, and Kim Ziya is going to deal with this in more detail, but the examiner will consider the basic conditions set out in Para 8.2 of Schedule 4B to the 1990 Act. And there are the following conditions. First, having regard to national policies, basically, the question is whether it's appropriate to make the plan. And then second and third, one takes into account the listed building and conservation area issues and ask again whether or not it's appropriate to make the plan. Then it's necessary to ask whether the plan contributes to the achievement of sustainable development. Then E, an important one, making of the plan is in general conformity with the strategic policies contained in the development plan for the area. And lastly, the making of the order does not breach and is otherwise compatible with EU obligations. There is another requirement actually that it should be in accordance with any other prescribed basic conditions, but those don't exist. So these are the principal conditions that need to be assessed. So looking at those, and again, I don't want to deal with this in any real detail. You have the slides, but I'll just touch on the points. And in particular two, basic condition A and basic condition E. Looking at basic condition A, one, as I said, has to consider, or the examiner has to consider, having regard to national policies and advice and guidance, whether it's appropriate to make the plan. Now that is not to be equated with soundness, and that means Para 35 requirements in the NPPF, need for proportionate evidence, meeting OANs, need to be consistent with national policy, for example. Those are not engaged in respect of the assessment of appropriateness. Second point is, and it's at the bottom of this slide, note that it's not a requirement to be consistent with national policy. What it is, and the court said this in VDW trading, is a requirement, simply a discretionary requirement to determine whether it's appropriate that the plan should proceed having regard to national policy. So note that, a discretion. Basic condition E, in general conformity with strategic policies contained in the development plan, note that is not concerned with the difference between individual policies and strategic policies. It is concerned with the strategic policies as a whole, but it isn't the whole plan that contains the strategic policies. That's to say, for example, a local plan. It's looking at the strategic policies. And note that the condition is not engaged if there are no strategic policies in the local plan itself. There is elasticity in the assessment of basic condition E, which does allow for conflict with strategic policies. So note that. Other issues that the examiner will have to bear in mind are these. Firstly, that the consideration must only be of the basic conditions except compliance with the European Convention. The second point is that there must be an assessment of the policies and the degree to which they relate to the development and use of land, not aspirational policies. Those are not the policies that are to be considered in the context of basic conditions. And those are matters that will have to be engaged with by the examiner. The examiner benefits from the court's recognition of their role as experts in their field, which means that the courts will work from the presumption that the examiners have properly understood the NPPF, just as in the case of specialist planning inspectors. So those are the issues. I said that there was a question for considering the apparent fairness of the procedure, and the Leggett case dealt with that, albeit in the context of the relationship between neighbourhood forum members and local authority officers. But what that highlights is the need to be aware of the potential for bias. And again, the REC's guidance gives support and some direction for considering that issue. So then there's the hearing report itself, and the report will either lead to the conclusion that the plan should be submitted to referendum, or that there are modifications that are needed to achieve the referendum, but if they're made, the plan can go to referendum, or the process is refused. The examiner has to consider whether or not there are changes that should be made to achieve the basic conditions. If the examiner recommends that the plan should go to referendum, the examiner has to consider whether or not the referendum area should be wider than the neighbourhood plan area. And when considering that issue, the PPG asked that there is consideration as to whether there is a substantial direct and demonstrable impact beyond the neighbourhood area. And it's within that test that the consideration of the wider area should be considered. So then, looking at the report itself and the reasons for each of its recommendations, the reasons to be given by the examiner rather, the reasons are for each of its recommendations and to contain a summary of the main findings. Now, what does that mean? Is it a Porter test? See the relevant guidance of the House of Lords. The original position back in 2014 was that yes, it was the Porter test that had to be applied, but it's slowly been drawn back, particularly by Mr. Justice Holgate in the Crown Law case, and then also by Mrs. Justice Lang in the Bewley Holmes case and the Lockhart investments case, where it's said basically, of course, the examiner is not an appeal inspector. The roles are different. His or her role is inquisitorial, not adversarial. So you don't have the same requirement to consider the principal controversial issues in the same way as you would do with an appeal inspector. And that was then reiterated in the Wilbur Developments case as well. Forgive me, the Bewley Holmes case, I said that was Lang. It was in fact Mr. Justice Dove, I think. So there we are. That's the report examination requirement and the reasons that need to be given. The re-examination process is one that can still take place, and that can happen if there is a difference from the LPA's perspective with some of the recommendations. They have a discretion to refer that to the independent examiner. Of course, if they don't refer that to the independent examiner, there's the potential for challenge subsequently. And so the re-examination process will look basically at the original issues. Just note that the examination process is as I've set it out. It applies the basic conditions, and that is an apparently lighter touch than the tests that to be applied to the local plan processes, for example. And that means that there is a much higher chance of being able to defend it on challenge and a much higher chance of the plan getting through the examination stage. As something that Sasha White has already referred to. So that's the examination process. What I propose to do now is hand over to Kim Ziya, who's going to go on to the basic conditions in more detail. Kim, over to you.
Thank you very much. Now, Matt has already touched on what the basic conditions are. Let me skip back. But just to reiterate them there on the slide, Kate and Matt have already touched on this, but you're looking at paragraph 8, subparagraph 2 of Schedule 4B of the Town and Country Planning Act 1990, and there are 7 basic conditions listed there, and I've paraphrased them on that slide for you. Essentially, most of the case law has focused on A and E, so these requirements to have regard to national policies and guidance, and the requirement that the plan be in general conformity with the strategic policies in the local plan. So that's what my talk is those are the 2 that my talk is going to focus on today. But then towards the end, I'm going to come on to the PPG guidance, which provides a bit of insight into some of the other conditions which are touched on less in the case law. Now, Matt has already touched on some of the key cases in his talk, so my plan for the next 10 minutes is to sort of delve into that in a little bit more detail and look at sort of how these basic conditions are applied in practice. So starting with the BDW trading case, this is from 2014, and this was all to do with the Tattenhall neighbourhood plan, and there was a challenge put in. The challenge was to the decision to put the plan to a referendum on the ground in part that the council had failed to ensure that it met the basic conditions, and specifically basic conditions A and E. And this is specifically because of one policy in the neighbourhood plan, the first policy, which was trying to limit the size of new housing sites within or adjacent to the neighbourhood plan area to 30 homes. So it wasn't limiting the overall scale of development. You could have as many of these sites as you wanted, but you couldn't have more than 30 homes per site. And the developers who were challenging the plan said, well, this couldn't be progressed in advance of the emerging local plan. And I know we've had a question submitted in advance about how you progress a neighbourhood plan alongside an emerging local plan. And essentially what the developers there tried to say is that the constraint mechanism on housing was not appropriate in trying to deliver the objectives of the NPPF, so you're in breach of the first basic condition there, and further that there were no strategic housing policies within the existing local plan, and therefore you couldn't judge whether the neighbourhood plan met basic condition E, because there were no strategic policies to measure it against. And finally, they said that there was not sufficient evidence to justify the neighbourhood plan housing policy. Now, Mr. Justice Supperson rejected all of those submissions. He said that basic condition A only requires what it says on the tin, namely that you have to have regard to the national policies, and having regard to those, is it appropriate that the plan should proceed. So this isn't the same as needing to be consistent with national policy in the way that a local plan has to, or that proper test of soundness. Further, basic condition E only requires general conformity with the adopted development plan policies as a whole. So it's wrong to criticise an inspector for not considering wider ramifications of a neighbourhood plan on the delivery of housing, because you can't confuse the limited role of an examiner of a neighbourhood plan, or the lighter touch role, as Matt has put it, with the greater investigative scrutiny of a local plan examiner. So it doesn't matter that there weren't already strategic policies in place, and we're going to come on to that in one of the other cases shortly. So the next case that I want to discuss is the Woodcock Holdings case, and this is often seen as quite a seminal case on neighbourhood plans and the basic conditions. And this is a decision of Mr. Justice Holgate, and he goes through again the decision in BDW that we've just discussed, and he also considers another case which I apologise isn't on the slide there, but it is in Matt's slides, which is the Gladman Developments and Aylesbury Vale case, which is helpful just to touch on briefly. And the claimant there argued that it was not permissible to include policies for allocations of housing sites and delineation of settlement boundaries in a neighbourhood plan at a time that there was no adopted local plan with strategic housing policies to deal with the objectively assessed housing need. Now that challenge failed because general conformity with the strategic plans is only required where those strategic policies exist. Same as what is said in the DLA delivery case, which I'm going to come on to. If you don't have any strategic policies in the adopted local plan, then the neighbourhood plan can't not be in conformity with them, rather than the other way around. So Woodcock, going back to the Woodcock case, this doesn't directly concern the adoption of a neighbourhood plan, but rather the decision of the Secretary of State to dismiss an appeal on the basis that proposals conflicted with and were premature in relation to an emerging neighbourhood plan. Now, this is an interesting case because it deals with, it's in some senses slightly similar to the first case that we discussed of BDW, because it's also dealing with a policy that's trying to limit the number of houses to come forward on sites within the neighbourhood plan area. But this time it was identifying that only 30 to 40 houses were suitable in the entire area. So rather than saying that each site was limited to 30 houses, you could only have 30 to 40 houses max. And there, Mr. Justice Holgate said, well, actually, that probably wouldn't satisfy basic condition to have regard to the NPPF. So the first basic condition, in particular, the need for flexibility and to plan positively for growth, unless it was amended to remove that overall total cap. So unlike in BDW, this was an overall limit and that wouldn't meet that basic condition. Further, however, Mr. Justice Holgate is on to reiterate that the absence of an objective assessment of housing need does not go to the issue of whether the basic conditions have been met. So this is where the neighbourhood plan threshold is lower than the local plan threshold. So touching briefly on DLA delivery, this is a Court of Appeal decision of Lord Justice Lindblom. Here, a judicial review of a decision of the council to take a neighbourhood plan to referendum, which was dismissed. Again, looking at whether the council misunderstood and misapplied basic condition E in this case, so the general conformity with the strategic local plan policies. And here, this is confirmation, I suppose, in response to the question that we've had in advance, that you can satisfy basic condition E. Again, the court has really stressed this on several occasions now, even where there are no relevant strategic policies in the extant local plan, and it's not premature to say that the neighbourhood plan conforms while the emerging local plan is still in draft form. Of course, if the LPA subsequently produces and passes through examination a local plan that is inconsistent with what the previous neighbourhood plan says, the local plan will take priority. So it doesn't matter that you're passing a neighbourhood plan before the local plan goes through its examination process. And finally, just to touch on the Lochalot investments case, just because it's such a recent decision and it's got quite a helpful summary, I've put the paragraphs there, 95 to 98, of all the case law that I've been through on the basic conditions. And this considers, it touches on compliance basic condition D, which is the need for sustainable development, which is quite unusual. I mean, it only touches on it very briefly, but effectively that the examiner just needs to consider the relevant paragraphs in the NPPF dealing with sustainable development, and that they did that in this case, and therefore that basic condition was met. So turning now just to some policy on basic conditions, and what we're looking at really primarily is NPPF paragraph 13, which says that neighbourhood plans should support the delivery of strategic policies contained in local plans or spatial development strategies, and should shape and direct development that is outside of those strategic policies. So this sort of reflects again that basic condition E that we've talked about. Then in paragraph 29, which is illustrating the purpose of neighbourhood plans, which is to give communities the power to develop a shared vision for their area, but then goes on to reflect basic condition E and noting that they should not promote less development than set out in the strategic policies for the area, nor undermine those policies. And then footnote that 16 is a reminder about this need to be in general conformity with the strategic policies contained in any extant development plan. And then paragraph 37 simply reiterates the need to comply with the basic conditions. More interesting and more helpful perhaps is the PPG guidance on basic conditions, and you've got it's paragraph 65 to 79. I won't go through this in any detail because I've summarised the key paragraphs there for you, but it does give you some more detailed guidance on each of those basic conditions, and noting, as Kate did in her talk, that these have to be considered throughout the process of developing the neighbourhood plan, and that the basic conditions statement is very, very important in this context and should be prepared in advance and early on in the process and shared with the local planning authority so that any concerns can be raised early on and discussed. And as I've flagged there, we've got paragraph 67, so the local authority should be looking to provide constructive comments on the neighbourhood plan and its compliance. And I've set out there essentially what the key paragraphs are dealing with each of the basic conditions. And something which may be relevant to a question that I've seen come up on the chat is the final bullet point there, which is what are the relevant EU obligations that you need to be complying with? And obviously these will change, and the basic condition is not designed to prescribe which EU obligations you have to comply with. They will just be whichever ones are relevant to that particular plan at the time. But the PPG suggests that you should be looking at the sort of standard EU directives that you'd be looking at in any planning situation, which is the Strategic Environmental Assessment Directive, the EIA Directive, and Habitats and Wild Birds Directives. But you should also be bearing in mind the Waste Framework Directive, potentially air quality or water framework directives if those issues arise. It will very much depend on the contents of your specific neighbourhood plan and the policies that are set out within it. So thank you very much. That was a very quick run through. Please do send any questions if you have them. And I'm going to pass over now to Andrew, who's going to be dealing with weight and development control decisions in relation to other development plans. Thank you.
Thanks, and good morning, everyone. As Kim said, I'm going to be talking about the weight to be attached to neighbourhood plans in development control decisions and also in relation to other development plans. And if I start with the position where there's a made neighbourhood plan in place, as is well known, that neighbourhood development plan is part of the statutory development plan for the area that it covers, and it has the same legal status as a local plan. So far as determining planning applications, of course, the starting point is that there's a presumption in favour of the development plan unless material considerations indicate otherwise. And that's reflected in the language of paragraph 12 of the NPPF, which states that where a planning application conflicts with an up-to-date development plan, including any neighbourhood plans that form part of the development plan, permission should not normally be granted. And that in turn, paragraph 12, largely reflects the language of paragraph 198 of the 2012 NPPF, which stated that where a planning application conflicts with a neighbourhood plan that's been brought into force, planning permission should not normally be granted, although now there's an additional reference to the need for the neighbourhood plan to be up to date. I think it's important not to overstate the importance of paragraph 12 of the NPPF. As Mr. Justice Holgate explained in the Woodcock Holdings case, they're describing the effect of paragraph 198 of the NPPF. That neither gave enhanced status to neighbourhood plans or modified the application of section 38(6) of the 2004 Act. And in my view, the same approach should be taken to paragraph 12 of the 2019 NPPF. So overall, there's nothing in law or policy to give an enhanced status to neighbourhood plans as opposed to local plans. They're of equal status. And the weight to be given to any breach of a neighbourhood plan is ultimately for the decision maker. This may be substantial. For example, in the Keith Langmead case, Mr. Justice Lang held that the Secretary of State was entitled to place substantial negative weight on the conflict between the proposal and a neighbourhood plan policy that sought to oppose development beyond the built-up area. But the weight given need not be as significant as that. For example, the Cherwell case, where a neighbourhood plan policy which stated that there shouldn't be development of more than 20 dwellings in any location at any one time, was only given limited weight by the Secretary of State. So overall, the weight to be attached to a breach of a neighbourhood plan policy is a matter of fact, degree and judgment. And therefore, it's very difficult to predict the outcome where there's a conflict with a neighbourhood plan, because even more so than for most planning decisions, there appears to be a very political dimension to decisions, especially at the Secretary of State level. So I'm going to look now at the position where there's no 5-year housing land supply. And of course, in that situation, paragraph 11D of the NPPF is engaged for housing applications by virtue of footnote 7 of the NPPF. And that means that planning permission should be granted unless, 1, the application of policies in the NPPF that protect areas or assets of particular importance provides a clear reason for refusing the development proposed, or 2, any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies and the framework taken as a whole. And paragraph 11D2 is the so-called tilted balance. Recently in the Gladman case, it was confirmed that breach of development plan policies, including neighbourhood plan policies, may be taken into account and given weight under the tilted balance as an adverse effect. And in doing so, the courts have established that the weight to be attached to those policies, when they're deemed to be out of date by virtue of the lack of a 5-year housing land supply, is for the decision maker. It's not prescribed in the NPPF. Some of the factors to take into account in deciding how much weight to give to those policies is the nature and extent of the housing shortfall, the reasons for that shortfall and the prospect of it being reduced, and whether the overall spatial distribution strategy remains sound. And then finally, of course, breach of neighbourhood plan policies may also result in harm to the social dimension of sustainable development. There's an important limitation on the operation of the tilted balance in paragraph 14 of the NPPF, which formalises in policy the approach that was taken in the written ministerial statement of December 2016. And I've set out paragraph 14 on the screen. So the adverse impact of allowing development that conflicts with a neighbourhood plan is likely to significantly and demonstrably outweigh the benefits, provided that all of the following criteria applies. So the first is that the neighbourhood plan became part of the development plan 2 years or less before the date on which the decision is made. Secondly, the neighbourhood plan contains policies and allocations to meet its identified housing requirement. C, the local planning authority has at least a 3-year supply of deliverable housing sites against the 5-year housing land supply requirement, including any buffer. And finally, the local planning authority's housing delivery was at least 45% of that required over the previous 3 years. So where those criteria apply, the tilted balance is in effect nullified and almost goes the other way. So there's a strong incentive there in policy for neighbourhood plans to allocate sites, especially in areas that don't have a 5-year housing land supply. And just picking up on two of those criteria that can cause difficulties in practice. The first, criteria A, i.e. that the neighbourhood plan became part of the development plan 2 years or less before the date on which the decision is made, that will still apply where a neighbourhood plan is updated through a material modification to the plan within 2 years of the decision, provided that all the other criteria continue to be met. And secondly, in order for a neighbourhood plan to meet the criteria in paragraph B of paragraph 14, i.e. that the policies and allocations in the plan should meet the identified housing requirement in full, that applies whether it's derived from the housing figure for the neighbourhood area set out in relevant strategic policies, or is an indicative figure provided by the local planning authority in a situation where those strategic policies are out of date or don't provide a housing requirement for the local area. So to answer one of the questions that's come in, a neighbourhood plan does need to contain allocations in order to benefit from the protection of paragraph 14, even where there's no assessment of housing need for that area in the local plan. And in that instance, it would be appropriate for the neighbourhood plan to seek an indicative housing requirement figure from the local planning authority. It's clear that a policy on windfall allowance alone would not be sufficient, and also that policies and allocations within other development plan documents, for example, strategic site allocations or a windfall policy in a local plan, will not meet the criterion, even if they're relied on by the neighbourhood plan. So to give one example of this, in the Dimmick Road appeal, the inspector found that paragraph 14 was not engaged because whilst the neighbourhood plan supported the allocations found in the local plan and included policies addressing the appropriate densities of these sites, the neighbourhood plan itself didn't allocate any sites for housing. Since, as we've heard, there's only a requirement for neighbourhood plans to be in general conformity with local plans, there's considerable potential for conflicts between policies in neighbourhood plans and local plans. And that's addressed in section 38.5 of the 2004 Act, which states that conflict between a policy in a neighbourhood plan and a policy in a local plan or spatial development strategy must be resolved in favour of the policy which is contained in the last document to become part of the development plan. And that legal test is reflected in paragraph 30 of the NPPF, which states that once a neighbourhood plan has been brought into force, the policies it contains takes precedence over existing non-strategic policies in a local plan covering the neighbourhood area where they're in conflict, unless they're superseded by strategic or non-strategic policies that are adopted subsequently. So where both plans are coming forward at the same time, this creates some advantage to being the last plan to be adopted, since that will take precedence over the earlier adopted plan. In effect, a race to be last. So finally, I'll come on to emerging neighbourhood plans. These are, of course, a material consideration for the purposes of section 38.6, and the weight to be attached to emerging neighbourhood plans is to be judged in accordance with paragraph 48 of the NPPF. And that says that local planning authorities may give weight to relevant policies in emerging plans according to A, the stage of preparation of the emerging plan. The more advanced its preparation, the greater the weight that may be given. B, the extent to which there are unresolved objections to relevant policies. The less significant the unresolved objections, the greater the weight that may be given. And C, the degree of consistency between the relevant policies in the neighbourhood plan and the NPPF. All three factors are relevant and must be considered in every case, and that's clear from the Woodcock Holdings judgment. It's worth noting, as Kate mentioned earlier, paragraph 107 of the PPG, introduced as a result of the coronavirus, which makes clear that where the local planning authority has issued a decision statement under Regulation 18, sending a neighbourhood plan to referendum, that plan can be given significant weight in decision making. So the weight that can be attached to emerging neighbourhood plans can be sufficient to tip the planning balance. And a good example of this is the appeal decision that I put up from March 2020, where the inspector attached substantial weight to an emerging neighbourhood plan which had passed examination but not referendum in refusing permission on a non-allocated housing site. And then finally, looking at the relationship between emerging neighbourhood plans and other emerging plans. It's now well established that neighbourhood plans can be developed before or at the same time as a local plan, following the Court of Appeal judgment in DLA delivery. Where a neighbourhood plan is proceeding in advance of an emerging local plan, there must of course be general conformity with the existing local plan in force at the time, although bearing in mind that, as Kim and Matt have said, there's a considerable amount of flexibility and discretion in that test. However, the neighbourhood plan will need to take into account the evidential basis of the emerging local plan on issues like housing need, because that's relevant to the question of whether the neighbourhood plan contributes to the achievement of sustainable development, which is another basic condition. And it's important that any conflicts with the emerging local plan are minimised, since if the local plan is adopted after the neighbourhood plan, any conflicts would be resolved in favour of the newly adopted local plan in accordance with section 38.5. So, for example, if the neighbourhood plan promotes less housing than the housing requirement in the emerging local plan, its policies may very well be out of date on adoption of the local plan. Nevertheless, there's an increasing trend of neighbourhood plan examinations and local plan inspectors reaching contrary findings in short succession. And we can see that in the Olley case. And in that case, in July 2019, the neighbourhood plan examiner decided that designating 10 sites as local green space met the basic conditions. And as part of the challenge, it was said that that decision was irrational because on the 2nd of September, the council took the decision to accept the neighbourhood plan examiner's report and proceed to referendum. But 8 days later, the local plan published an interim report. The inspector published an interim report finding that some of the local green space approved by the neighbourhood plan examiner were not sound and were unjustified. Mrs. Justice Lang found that this did not demonstrate irrationality, and she noted that the neighbourhood plan examination was independent of the local plan examination. And the council could not have taken the local plan inspector's findings into account since it post-dated their decision. And she placed a great deal of emphasis in the different statutory roles of the neighbourhood plan examiner as compared to the local plan examination inspector. I think, of course, that's all correct and it makes legal sense, but it is fairly unsatisfactory to have two conflicting decisions in such a short period of time. And to my mind, this could be seen as an argument in favour of standardising the approach to be taken to neighbourhood plan and local plan examinations to avoid such conflicts occurring in the future. And then I've also put up there the Wilbur development case where similar issues were raised. So I'll hand over to James now, who will be looking at how to challenge a neighbourhood plan and when to do so.
Thanks, Andrew. I'm going to touch on some of the practical implications of challenging a neighbourhood plan. And in particular, I'm going to focus on some of the issues that arise in relation to time limits for bringing such challenge. The section 61 N of the Town and Country Planning Act is the key provision which provides for legal challenges in relation to neighbourhood plans. It was essentially designed to avoid the unsatisfactory situation whereby an authority could go through all the process of considering an inspector's recommendation referendum and then making the plan, and only then a challenge happening. And essentially the legislation provides for and mandates challenges to be brought at earlier stages in the process, and in particular for a challenge to be brought to the substantive consideration by the local planning authority of the inspector's recommendation at that point, rather than waiting until the end. And I'm just going to go into that in a little bit more detail in this presentation, because it has caused a number of difficulties, and there have been a number of High Court judgments considering this provision. So what does section 61N actually say? Well, I put it up on the right-hand side of that screen. It is fairly complicated and slightly unhelpful in that when setting out the three circumstances in which a court may entertain proceedings for questioning various decisions in relation to the neighbourhood plan process, it doesn't actually follow a chronological order. So on the left of this screen, on the left of the slide in front of you, I've set out the three stages in chronological order at which should be challenged or can be challenged under 61N. The first stage, stage one, is, as I said before, the local planning authority's consideration of the examiner's recommendations, and including the consideration by the local planning authority as to whether the prescribed conditions, including the basic conditions mentioned in the previous presentations, have been met. And that stage 1 is provided for, or challenge to that is provided for in subsection 2 of 61N. Stage 2 relates to anything, or provides for a challenge to be made to anything relating to a referendum, and that's set out in subsection 3 of 61N. And then finally, there's a final opportunity to bring a challenge at stage 3, which is the actual making of the plan after the referendum. And if I could just draw your attention to subsection 1, it says a court may entertain proceedings for questioning the decision to act under section 38(4) or 6 of the Act. Now, just pausing there, subsection 4 of section 38A says the following. It says, a local planning authority to whom a proposal for the making of a neighbourhood development plan has been made must make the plan if the referendum effectively has passed the sufficient number of votes, or sufficient number of votes have been achieved. Subsection 6 of section 38 says that the authority are not subject to a duty under section 4 to make the plan if they consider that the making of the plan would not conform with or be incompatible with any EU law obligation. Now, it's that particular, and we'll come on to look at this in the case of Oyston in a moment, but it's that particular carve out from the duty to make a plan under section 38(4) on the grounds of a breach of EU law that has caused difficulties when deciding whether to bring a challenge or not, and at what stage. So just looking at a bit more detail at what the implications of 61N are, I think the key point and the key sort of takeaway from my presentation is, if you're thinking of challenging a neighbourhood plan, do not wait, if at all possible, until the plan is made. The Court of Appeal last year clarified that the section 61 and the provisions there are not entirely permissive. And the critical point is, if a challenge is brought that in truth is attacking the substance of a stage 1 or stage 2 decision, then claimants can't choose to wait and rely on stage 3, the making of the plan stage. You've got to move earlier. And I've set out the key subsection, the key comment from the Court of Appeal at paragraph 39. I'm not going to read that out. Now, that's the key. So that's the key point. Don't wait until the plan is made. Secondly, what's the process? Well, it's via judicial review, not via statutory review. And there are 6 weeks to bring a claim. So that's the key limitation period. But unlike judicial review, even though judicial review is specified as being the process by which challenge is brought, critically, there's no discretion to extend time under 61N. So it's unlike a normal, inverted commas, judicial review in that respect. The other critical point, and an important practical point, is if actually challenging a stage 1 decision, so challenging the local authority's decision to accept an inspector's recommendation to proceed to referendum, then it's very important that claimants either get an undertaking from the local authority or seek interim relief, stopping stages 2 and 3 going ahead. And that the claimant in the case I put up on the screen, Hoare and the Vale of Whitehorse District Council, fell into that trap. They identified some legal flaws at stage 1, but they didn't hold up stage 2 and 3. And the court effectively said all that they might get is a declaration, not a quashing of the adopted neighbourhood plan at the end of the process. And a good example of an interim of injunction being sought. The first one, as I understand it, was granted was in the Olley case that the previous speakers have already referred to. So that's pretty important for claimants to bear that in mind. Now, I mentioned section 38.6 and the obligation on authority at the end to consider about whether EU law obligations are incompatible with making the plan. Now, that means, in theory, if the view is that the plan you're considering is contrary to, say, the habitats regulations or any other EU law provision, then you could bring a challenge to the making of the plan at the end and not wait. And that happened in Stonegate Homes. But that seems to be what happened in Oyston Estates, or that seems to be the reason why the claimant in Oyston Estates waited. I'm not going to go through the full facts of this case, but in summary, the local planning authority rejected the examiner's recommendation to make a modification, and they did so on the basis that they thought on the basis of advice from Natural England, that the examiner was wrong to say that the modification could be made without an appropriate assessment, and that it could all be dealt with at project level later on. Now, the claimants waited until the end, so the making of the plan, to say, well, that's contrary to EU law, not its own, and the court said, no, you're arguing about the local planning authority's reason not to accept a recommendation, and in doing so erring in law. You're not actually saying that the plan itself breaches EU law, the plan itself is adopted. So on that basis, it was held out of time, the claimant was out of time to challenge the stage 1 decision, because in truth, the court said that is what the challenge is directed at. So those are some of the complications that can arise when looking at when to challenge. Very briefly, just looking at what can be raised in a legal challenge to a neighbourhood plan. Well, the best summary for this is set out in the Olley case that's already been referred to, and this Justice Lang there has confirmed the general principles. Essentially, a challenge can be brought on standard public law grounds that we're all, many of us I'm sure are all familiar with: misdirection law, irrationality, etc. And again, Ms. Justice Lang repeated the normal mantras you hear when challenges are brought to inspectors' decisions, including the point often heard in defence of the claims that inspectors' reports, including examiners' reports, should be read without excessive legalism or exegetical sophistication. So those are the main principles applying to what can be raised in a legal challenge. Now, that was a brief canter through. I haven't dealt with costs and some of those procedural implications because I don't have time, but I hope that sets out a very brief summary of some of the issues that can arise or practical issues that can arise when considering when and how to bring a challenge to a neighbourhood plan. And I'll now hand you over to, I think, Sasha, who's going to chair the Q&A session.
Absolutely. Thank you very much to the 5 speakers for such an excellent set of presentations. And as James has said, I'm now going to ask some questions. I'm going to take it in the order of the speakers. So Kate, could I start off? One of the things that's been raised, and I think is an issue of major debate, is what's your view as to whether a neighbourhood plan in law can change the extent and nature of a greenbelt boundary under MPPF 136?
Well, I think it depends on what sort of change it is, and whether it goes to the broad need for a change, or whether it's dealing with detailed amendments once that need's been established. And I'd simply look to the wording of 1336. The need for changes has got to be established through strategic policies, but detailed amendments can be made through non-strategic policies, and it states in terms that includes neighbourhood plans. So it's just to be careful to focus on exactly what's really being proposed in substance.
Thank you. Now, the next question I wanted to ask you is about public consultation, because I know I've certainly received quite a lot of requests for guidance from neighbourhood plan organisations about what can actually be done. This requirement for consultation that is both compatible with the COVID restrictions and meets the requirements of the law. What would you say to those who have currently got neighbourhood plans and they're approaching the question of consultation? What can actually be done at the moment?
I think quite a lot. I mean, the Regulation 14 requirement, the 2012 regulations, Regulation 14, is actually quite broad. You have to publicise in a manner likely to bring the plan proposal to the attention of people who live, work or carry on business in the neighbourhood area. And bearing in mind, you've got to give the details of what the proposals are, where they can be inspected, how to make representations and by when. And you've got to put in your consultation statement, thanks to Regulation 15, how you've done that. To a large extent, I think the internet is your friend. You can certainly inspect documents online, and bear in mind also Regulation 16 actually requires LPAs to publicise a neighbourhood plan proposal on their website. But other than that, I think new paragraph 107 of the MPPG covers it, because it says it's not mandatory to use face-to-face methods. The difficulty, I think, is that because you've got to show sufficient engagement with all groups in the community, and it specifically says including those without internet access, that's why we've got these words. It might be necessary to use more targeted methods. So ringing people up, writing to them. I mean, obviously can't have a gathering in a town hall and an exhibition, but there's a lot that can be done, and I think would pass muster in current times. But good idea to be on the safe side, to ask the LPA for advice on suitable methods, and also how to reach certain groups in the community, because they might have experience of that. So that's what I would suggest. Thank you very much, Kate. Now Matt, can I first of all ask you, from your putting your paper together and from your professional experience, are you of the view that examinations under the neighbourhood plan legislation actually are an effective form of scrutiny in law and practice?
I think generally yes is the answer. When one looks at reports that I've been involved in, the approach that's taken towards compliance with the basic conditions, which is what needs to be looked at, is dealt with methodically, and that of course will mean, at least as a matter of law, that the plan has been considered properly and effectively. When one looks at the second stage in the report process, one sees there each one of the policies that need to be considered by the examiner being considered, and appropriate modifications being made to make sure that the plan does meet the basic conditions. Again, that's an effective approach that's usually set out by the examiners, and they've taken a robust approach to it. So I think that they are effective, but of course I've also been involved in other neighbourhood plans and reports in particular that don't deal with the sort of arguments that fully enough, the sort of arguments that have been raised, particularly by the consultees, putting to one side the qualifying body's own considerations. And when there are complicated points being made, one doesn't find sometimes that the reports do go into sufficient detail to address, from the consultee's perspective, the answers sufficiently. So generally yes, but there are, as one would expect, exceptions to that.
Thank you very much. And the other thing I wanted to ask you about, just to assist those who are involved in the examination process, can you summarise what circumstances would you advise it would be prudent to reopen an examination?
Yeah, well, I said before that paragraph 13 of Schedule 4B sets out the circumstances when, at least statutorily, the the LPA may consider that it's appropriate in the circumstances to refer the matter back to the independent examination, or the examination by the examiner. And that would include where there is a potential decision on the part of the planning authority to make a decision contrary to the examiner's recommendations, and to do so on the basis of a difference either on facts or as a result of new evidence. That's a statutory position. But I think it's also important to note that there's a broader authority or broader power on the part of the planning authority as a matter of protectiveness to send the matter back to examination if it's considered appropriate. And one obvious way is if there's been, or one obvious reason for doing so would be if there's been a threat of legal challenge, and it's important to try to address a particular issue because it can be addressed through consideration with an examiner, and to do so result in a more robust approach in terms of the ultimate plan that goes forward. That would be one reason for doing so. Again, if there are mistakes of fact on the face of the examiner's report, that would be a reason for going back to the examiner, or if some of the recommendations are just not understood. So those sorts of issues are ones that would be pretty obvious ones for sending it back to examination. Yeah, that's what I think.
Thank you very much, Matt. Now Kim, I wanted to ask you in the context of key questions in relation to the basic conditions. First of all, what do you say in law having regard to the national policies and guidance really means? What does that mean?
I think it's a difficult one because it is a relatively light touch test, and I think the DLA case is quite a good example of that. That actually what the judges are looking at is, has the inspector considered the relevant national policies? And in that case, it was all about delivery of housing and whether that was considered properly in accordance with the NPPF tests on delivery, which are obviously very technical. And the fact that the inspector had referred throughout his report to the relevant paragraphs in the NPPF seemed to suffice for them to say that that condition had been met. So I think it's not necessary to say it's a tick box exercise, but I think you do have to make sure that the report and any basic condition statements are going through that have addressed what the relevant policies are and why, if there is any inconsistency with them, that still seem as appropriate. It's still appropriate to make the neighbourhood plan. And I would just refer briefly to PPG 70, which I didn't expand on much in my presentation, which says that this condition does allow an examiner to take a view if there are conflicting, well, if there are different parts of national policies that need to be balanced. So you can take a view on that. You don't have to be in conformity with every single part.
Thank you. And also along those lines, looking at little e and the general conformity with strategic policies. General conformity, we've all got our own view, but in law again, what do you say, general conformity? What's been the approach of the courts to the test of general conformity?
I think it's a case of, again, as long as you're not undermining those policies, you can add detail to them, you can take a local approach that's specifically addressed in the PPG, but you can't be actively undermining the existing local plan policies so that those can't be met because of the policies in the neighbourhood plan. So one way of phrasing it is sort of support. You've got to support and uphold those strategic policies, even if you are departing from them slightly. And again, a good paragraph in the PPG is 74, which lists some examples of sort of how you might want to approach that test in practice, and it's quite helpful guidance in there. I
like that phrase. Yeah. Now, Andrew, can I move on to you? And I want to ask you to take your presentation. I want to ask you in practical terms, from your experience, when one looks at decision letters that are coming out of the inspectorate in 2020, what would you say, what weight are inspectors generally giving to breaches of neighbourhood plans? Is it determinative? Is it pretty weighty? Are they ignoring it? How would you characterise it, if you can, what the general approach is?
Well, as I said in my talk, in law and policy, neighbourhood plans don't have enhanced status, but in my experience, I think considerable weight is being given, especially where the neighbourhood plan is up to date in the sense that it meets the local housing requirements, and quite often that weight can be decisive. So I mentioned the I decision in my presentation. There's also there was a decision in Arran in December last year, which was a proposal for a sheltered housing scheme, and there was an acknowledged housing land supply shortfall, but a policy in the neighbourhood plan which had been recently approved at referendum. And the proposal didn't consider all the development options as required by the neighbourhood plan policy, and that was a significant factor in favour of the appeal being dismissed. And there were a number of other similar decisions at Inspector and Secretary of State level in the last 12 months. And I think that largely reflects the importance that the government attaches to neighbourhood plans, as you mentioned at the beginning, Sasha. And there's also a sense amongst inspectors, I think, that if the local community has gone through the time and the effort of developing a neighbourhood plan, its policies should ultimately be respected.
Doesn't it also seem that in the light of the I decision which you raised of March of this year, that obviously emerging plans have been given quite weighty considerations, and also the amendments to the MPPG seem to back that up as well? Is that your view? Yeah,
definitely. And I mean, I think that in many ways makes sense. I think, so the decision in I, and also what the PPG says, is that you give significant weight once you've passed examination pre-referendum. And I think given how few plans actually fail referendum, that makes sense, because in practical terms, once you've got through examination, in reality, you're very close to being adopted. And it also makes sense given current situation and the delays in referendums taking place. And I guess in many ways it provides an incentive or an additional reason to get on with a neighbourhood plan in a situation where there's a neighbourhood plan and also an emerging local plan. If emerging neighbourhood plans are being given such significant weight, and also given the timescales for local plan examinations and some of the difficulties that plans have received at examination stage, I think if you wait for an up-to-date local plan to come into force before moving ahead with a neighbourhood plan, you could be waiting for some time in some instances.
Thank you. Now, finally, James, I've just got two matters for you to finish on. In the light of the approach in the Hart case, do you think that it's going to become more prevalent to seek injunctive relief when you go at an earlier stage to effectively stop the plan progressing in the context of a potential challenge to the neighbourhood plan?
Sasha, yes, I do, because for two reasons. Firstly, the courts granted an injunction in Loch Islet and considered that effectively the American cyanamide tests were met, particularly serious issue to be tried and maintenance of the status quo. But also because it's expressly endorsed by Lord Justice Lindblom in Oyston. He there has said, well, it's always open to claimants to seek interim relief if they're worried about allowing the plan to be made pending a challenge. So I think it should actually be standard practice to seek an injunction if you can't get an undertaking from the local planning authority not to progress to the next stages of the plan process, where you're challenging the local planning authority's acceptance of the inspector's recommendations. So that seems to be, and that was made clear, that's been clear really since the case of Hoare and White Horse District Council, where it had the unfortunate consequence of the remedy not being granted, the very fact that they hadn't held up the making of the plan, even though there was a flaw at an earlier stage.
And James, what do you, to those of our audience who are potentially contemplating or on the receiving end of a challenge, if you could summarise, what do you say is the approach generally of the planning court to the kind of neighbourhood planning challenges in law that we've seen over the past 2 to 3 years?
Well, it seems to me that, I mean, if I was to describe in one word the approach the courts make is very deferential to the discretion of both inspectors and local authorities to accept their recommendations. I mean, if you look at the two cases that I think Andrew touched on in his last presentation, Wilbur and forget the name of the, off the top of my head, the other recent case, where you effectively had two contrasting decisions by two inspectors in relation to the local plan process and the examination process. You've got two conflicting decisions almost at the same time, yet the court still said that recognise that there are different processes and inspectors can make different decisions. So despite the unsatisfactory nature of that position, the court seemed to be, certainly Mrs. Justice Lang in those last two decisions, has dismissed both those challenges. So the court seemed to be, it seems to be very hard to successfully challenge a decision based on the exercise of the discretion of an inspector and an authority to accept it.
I think that's right. I would endorse what you said. Right, now, can I also say to those of our audience who've also sent in questions, there's some quite complicated ones there that we haven't dealt with, not because they're beyond the beyond the ability of us to answer, but purely because there are some quite significant details. So we will endeavour to answer those questions, and we'll add a written answer sheet to what's sent out. But as I said, the way forward is that there will be a link to the presentation which you can all re-watch, and the slides which our marketing department will send out. But it remains for me to say thank you so much for joining us today. I think it's been very, very good, and I'd like to thank the 5 presenters for 5 superb presentations, really good, really informative, and an excellent overview of their areas. So thank you very much, and do join us again. We have a good list of webinars coming up over the next month, and do come back. So thank you very much on behalf of all the panelists as well. Thank you.